Good morning, Mr. Shaskalsin. Good morning, Mr. Pano.
Chair.
Good morning, Mr. Karim.
Morning, Chair.
Chair, we've been informed that there may be an application for a postponement. I don't know more than that. Yes, Chair, thank you. We do require a stand-down to prepare an application for a postponement. To inform you about the developments that have led to this, if I can just very briefly tell you this, but I do want to bring a formal application. At about 6 o'clock this morning, my attorney received an email from the Commission's attorney, and the email read, "Our instructions are early this morning, flowing from your client's evidence yesterday. An evidence leader was working through the Medicare 24 Shwani accounts to identify inflows from SAPS in the period over which your client had sight of transaction movements on that account. While looking at these inflows into the Medicare account, the evidence leader identified 2 additional payments to Medicare from your client, which your client has not disclosed. The payments were in an amount of 1 million on 27 June 2024 and an amount of 1.12 on 7 October 2024. Both payments were made from your client's company, Tasmika Construction. Copies of the relevant Medicare and Tasmika Construction bank statements are attached, together with extracts from the spreadsheet of contras for the Medicare account, which was provided by FNB. The evidence leaders intend to canvass these payments with your client this morning. If you require time to consult with your client in this regard, we will approach the Commission to arrange a later start to proceedings." Chair, we all got here between 9 and 9:15. We've barely had an adequate opportunity to consult to this, but that said, what is provided to us are several bank statements and a spreadsheet, which obviously the Commission had prepared well in advance of this morning, 6 o'clock. Somebody had done this investigation. We've continuously complained of having documents kept back from us and drip-fed, and this is yet another installment in that. To give background to this, we wrote on the 7th of March and on the 8th of March. I will deal with the correspondence in detail in the postponement application, but essentially on the 7th of March, between those 2 letters, we asked the Commission, because we were being given things, as we said, drip-fed, we asked the Commission to please tell us all of the documents that they intended to use and rely on. And we said, as reluctant as we were, this conduct of the Commission, obviously of the evidence leaders, was going to give rise to a postponement. That is but one aspect of it. What also happened is, you recall yesterday, you were told that there was 1 or 2 pages of documents, additional documents that were found, and our learned friends would not deal with that yesterday, but they would deal with that today. Well, we asked for the documents. They had been sent electronically, I think, whilst we were on our way to the Commission yesterday. Didn't help anybody, certainly not us, when you look at the nature of the financial statements, and we asked for hard copies. At approximately 2 o'clock, 1 copy of this was made available after we had started. At 4 o'clock, we got sufficient copies for our team, and this is what we got. I'm holding it up. It's a file full of hundreds of pages of spreadsheets and detailed analysis that had been done. So we expected to have been sitting here dealing with Mr. Suleiman's evidence yesterday, and I said to you, on the hoof, expected to go through all of this. Clearly, one can just estimate they literally hundreds of pages, and let me show you, if you can see from where you are, what they look like. The documents look like this: intense line items of hundreds and hundreds, if not thousands, of transactions. Now, it might be that the Commission says it's not intending to refer to all of those transactions, but we have simply not had an adequate or fair opportunity to deal with this. So I want to deal with all of this formally in an application, and I'd like to stand down to bring that application. I think for current purposes, if we have till 12 o'clock, we should be able to get the application out.
Yes, Mr. Shaskalsin.
Chair, there are two separate issues to address here. The first is the hundreds of pages that Mr. Barnes is brandishing around, and second is the bank statements for 4 months of Tasmika Construction and Medicare. Let me deal with the spreadsheet first. We will not refer to a single one of those pages. We've made that clear to Mr. Karim's team. Why we gave it to them is that there is an infographic on page 505 of the bundle that they've had for some time. What we sent them electronically, and the infographics provides a summary of payments from municipalities in the area in respect of which Mr. Karim is the ANC treasurer, to companies owned by Mr. Karim. And it gives a breakdown of where the 336 million or 332 million that these municipalities have paid to Mr. Karim, where it comes from. The infographic provides a summary. We thought that Mr. Karim would want to know where we got the infographic from. So we gave him a spreadsheet with line items of every single transaction reflecting a payment from one of those municipalities to a company of Mr. Karim, with tabs broken up by company. And we made clear to him we're not going to refer to any of those line items. They are totaled, but if he wants to total them himself just to check that our numbers on the infographic are right, he can do that. If he wants to dispute any of those transactions, he can do that. He had that electronic spreadsheet, which is really the only sensible one.
For how long has Mr. Karim had what you say is at page 505?
505 was served with the rest of the bundle on Friday. The electronic spreadsheet was emailed to him yesterday morning before the commencement of proceedings. It was always explained to him that we are not going to refer to any line items on the electronic spreadsheet. That leaves the bank statements for Tasmika and Medicare that were provided this morning. And the background to their discovery is the following. Yesterday in evidence, Mr. Karim told us for the first time that he had had sight of Medicare bank statements over a period in 2024. This was material that should have been put in a statement, which in turn ought to have been furnished Friday, not last week, but the week before. It wasn't put in the statement, which was furnished 5 days late on Wednesday. So we hear this for the first time yesterday. Following from that, I was going through the Medicare bank statements at 5 o'clock this morning, looking to see what SAPS inflows were there to interrogate the version of Mr. Karim in relation to the terms of his loan agreement and the idea that he was going to get 10% of all SAPS inflows, but he had waived all of that. I wanted to see how much money he had waived. While I was looking for that purpose, I stumbled across the fact that there were 2 substantial payments from Tasmika Construction, another company of Mr. Karim, into Medicare 24, which he didn't mention in his statement, and which I would like to ask him about because he certainly should have mentioned them in his statement. The one payment is a payment of 1 million on the 27th of June 2024. The second payment is a payment of 1.12 million on 7 October 2024. There is no innocent explanation for just overlooking the fact that more than 2 million rands beyond what you have disclosed also happened to be paid. The reason that these documents were made available to his legal team today and not earlier was, first of all, he filed his statement late. Second of all, in his statement, he didn't disclose these payments. Third of all, in his statement, he didn't disclose the fact that he was he had sight of the bank transactions on Medicare 24. So in any one of those 3 respects, they would have had these bank statements more than a week ago. So they can't complain about getting them now. And the bank statements really reflect 4 payments, which I have, 2 payments which I've described on both sides. If they want 45 minutes to take an instruction from Mr. Karim, if they want an hour to take an instruction from Mr. Karim, I can understand that. They need to understand what his version is, whether he was concealing them, whether there is an innocent explanation. But an hour is more than enough to do that. They then make the allegation that the contra spreadsheet that we gave them, just to show that not only do these numbers match, but in fact, they are shown by FNB to be the same transaction by virtue of the contras. They make the suggestion that we have had that document and withheld it from them. That is a very irresponsible suggestion. What we receive from FNB when we get bank statements from FNB is a list of all the contras. So we have contras for the entire Medicare 24 account, thousands and thousands of transactions. We don't search on that set of transactions for Tasmika construction unless we have reason to search for Tasmika construction. This morning, I had reason to search for Tasmika construction. So I searched for Tasmika construction and identified the two entries that were provided to them this morning. I then copied those two entries into a separate spreadsheet this morning, sometime between 5 and 6, and gave it to them. Nothing has been withheld from them. They received that spreadsheet within 15 minutes of its creation. They can look at the metadata of the spreadsheet. So in our view, they are entitled to a short stand down to take instructions on the documents that they withheld from us and that we have now discovered, or the information that they withheld from us and we have now discovered. They're certainly not entitled to a postponement. Thank you.
Thank you, Mr. Shoskelson.
Chair, just to be clear,
Yes,
this is not the postponement application. This is a request for a stand-on to prepare the postponement application. The attitude adopted by the Commission leaders is continuously to point fingers to Mr. Karim and his legal team when failings on the part of those evidence leaders are exposed. I'm not going to deal again with the statement being late because that is factually incorrect. But what we are entitled to do is to test what's in the infographic. As our learned friend himself accepts, the infographic is somebody else's creation of a summary. He appreciates that we needed the source documents, yet he put up the infographic, as you point out, as late as Friday afternoon, and with these source documents only coming on Monday morning whilst we were driving to the Commission, or maybe slightly before. So it's no satisfactory answer to say, we will not rely on any one of these documents. You are relying on the infogram, which is the reconstruction or summary of what is contained in here. We are entitled to check that. We are entitled to interrogate the infogram, and we are entitled to interrogate the information that you rely on for that. In relation, and we foreshadowed this yesterday in an attempt to avoid a postponement, which we also alerted the Commission to in the correspondence over the weekend. We said we did not want to apply for a postponement, but if documents and information was going to be withheld, we would be forced to do so. At that stage, we were writing about the transcripts pages. We didn't know what else they had up their sleeve, but we said we confirm, as a result of your failure to provide us with this information, we are compelled to advise that we may be left with no alternative but to seek a postponement to enable us to properly prepare our client on the supplementary bundle now provided. That's the Friday bundle. Yes. Then, not satisfied that the Commission was playing open cards with us, we wrote on the Sunday, and paragraph 6 of that letter, and we'll make all of this correspondence available in the postponement application. In the circumstances, we require that you unequivocally confirm in writing the following: an itemized list of the exact documents upon which you intend to rely for the purpose of questioning our client. 6.2, confirmation that no documents or information falling outside the scope of those identified documents will be relied upon for our client's appearance. that this correspondence, together with the prior letters referred to, will be placed before the commissioners so that they are fully appraised of the circumstances in which this issue has arisen and the manner in which our client has been required to engage with the process. So, yesterday, when we got here, I said to the Commission that we've got these documents, we've not looked through it. In an attempt not to delay, we suggested that we proceed, and if we had if we finished early, I said if we finished by 12 o'clock, it might give us a chance to look at those documents. As matters turned out, we were here past 4 o'clock, got to Santon at 5. People had to go off to break fast and for the evening prayers. So we have not had a sufficient chance to look at this, and it doesn't lie in my learned friend's mouth to say he's not going to refer to it. He's had this, he's produced it, and it's the basis, as you appreciate, Commissioner, that they produced. I think the document page is correct, 501, the infogram, 505, the infogram at 505. In relation to the spreadsheet, we want our learned friends to go on oath to say the spreadsheet was produced only at past 5 o'clock this morning. And we also wish to inquire about what other documents they've had and that they've looked at. Yes, in relation to the issue of Tasmika, our learned friend in his finger pointing, which has become habitual here, suggests that this should have been covered in the statement. Well, we want to remind the evidence leaders of what was asked for in the 10-6 notice of December, the one which superseded all other notices, and in fact they said was the new notice. You'll see in paragraph 2.3, our client is asked to deal with the nature and extent of relationship with a number of entities. There's 6 of them, and when you look at that, you won't find any mention of Tasmika. So we were hardly required to consider or take instructions on Tasmika. But Chair, we have attempted to get on with matters here. The Commission's drip feeding of documents, which we've complained about, has continued right until this morning. There's an overall interest of fairness that has to be applied here. Witnesses can't be expected to deal with things on the roof, or, in our respectful submission, for things to be withheld, whether willingly or unknowingly or unwittingly, and then for us to take instructions on the turn at a very difficult time when people are not readily available at night due to religious commitments, and then to say, well, you can have an hour and just deal with this. It's not the way matters should be conducted. This is highly prejudicial to us, and we do wish to bring a formal application.
Thank you.
Chair, if I can respond on just on 2 issues. I'm asked to depose to an affidavit confirming that I
Mr.
made
Bana will have the last.
He can have the last, indeed,
yes,
Chair.
yes.
I've been asked to depose to an affidavit saying that I created the spreadsheet at between 5 and 6 this morning. I confirm that I created the spreadsheet between 5 and 6 this morning. And that 2-line spreadsheet did not exist prior to 5 and 6, between 5 and 6 this morning. The answer, Mr. Bana, is if Mr. Bana wants to spend 2 days plowing through various line items, his client can, I won't touch that issue today, and his client can come back on Friday. I'm not prepared to make the same tender in respect of the bank statements because they infect all of the questioning. And there is, with respect, no reason why we should waste today because those bank statements and those payments were not disclosed. And the client was, the witness was specifically asked to furnish a statement on the nature and extent of his relationship with Medicare 24 Tshwane district. He declined to mention that one of his companies paid over 2 million rands to Medicare Tshwane district. That should have been in the statement on any scenario. So we're here today with this problem because the witness didn't disclose payments aggregating to 2.12 million into Medicare Tshwane district when he was specifically instructed to furnish a statement about the nature and extent of his relationship with Medicare Tshwane district. I accept that the witness now and his legal team now need time to consult, but they don't need time, they don't need days to consult. They can stand down, consult for a reasonable period, maybe an hour, and then we are ready to run. We oppose this suggestion that the matter should be stood down for a postponement application. If it stands down to 12 o'clock for a postponement application, the process itself achieves the postponement.
Please remind me again, which aspect do you say may be pushed to Friday?
The infographic and all of the underlying transactions. If they want to interrogate several thousand transactions, they can do so over the rest of the week. But they don't need the rest of the week to get a version on why payments of 2.12 million rands from Tasmika to Medicare were not disclosed in the statement and what those payments related to.
Thank you, Mr. Chaskalson. Any response?
Yes, thank you, Chair. Firstly, our learned friend concedes that the documents given this morning infect all of the questions. That alone should show how significant they are and why we shouldn't be just given an hour to look at the documents and to deal with that. But secondly, in relation to the point he keeps making, and loosely without referring to what the Commission actually inquired or required, the suggestion that because there was a request to deal with the relationship with Medicare, this should have been disclosed. What was not asked for in the statement is for any of these companies to deal with their relationship with Medicare, let alone Tasmika, who doesn't even feature in the 10.6 notice. The notice at the relevant paragraphs ask Mr. Suleiman Karim personally to provide a statement, and it says the nature of your relationship with Mr. Kat Matlala, Senzo Mchunu, and General Firoz Khan, the role you performed for Mr. Matlala, and then 2.3, the nature and extent of your relationship with the following individuals. There's no mention here of dealings of his many companies with anyone, let alone with Medicare.
Can I ask Mr. Bana, on that last point, if you take that attitude that there is no mention of explaining the relationship of his companies with Medicare, why does he tell us about the Ziggy 10 million rand payment? Because that is a payment from a company.
Yes.
That he is happy to disclose voluntarily.
Yes.
He disclosed it, and please make me understand why does he not think, or why you think that a disclosure about this later payment now doesn't fall in the same category?
Yes. There are two answers to that, but something else I'm going to make in submission. Firstly, when he deals with Ziggy, Ziggy is specifically mentioned in the 10.6 notice. But secondly, the fact that he might have, in explaining some of these things, dealt with some of the companies, let's assume Ziggy wasn't there, doesn't mean, therefore, I'm dealing just with the point to say you should have gone and investigated and disclosed in your statement, Tasmika, the culpability point. I'm saying there's no culpability here for him not dealing with Tasmika.
We are a commission of inquiry, which is fact-finding. We want to know when I think it doesn't sit well for a witness, by the way, a witness of the commission. Everyone who's, unless you have a different understanding of the people that are appearing before us here, they are all called by the commission to come and testify, and Mr. Karim is no different. For me, that's my starting point, and I hope we have a common understanding about that. And when they are called and they are asked questions or they are asked to address issues, the expectation is they will not be technical. They will not rely on, I will not say that with the commission doesn't know. They've asked me to come and explain my relationship with Medicare. If he speaks to Ziggy clearly, even if the notice from the commission mentions Ziggy, it's clear from that, I would have thought, that the commission is interested in the entities, that he's got his personal relationship and his entities. And if he intended to be open with the commission, I would have expected that he would speak to all the entities, including ones that are not mentioned in that notice, because he accepts that he's being called to come and assist us
No.
to determine the facts.
No, there's a false basis of what you're putting to me, a false premise. The witness is guided by what he's required to deal with in the summons and in the notice.
And
It
now
can't
he's
be-
here, okay, and now
Can-
he's
can
here.
Can I finish my
Okay, let me
submission?
just clarify myself so that when you finish your story, you can address what I'm wanting to clarify, because you're doing this for my benefit, not for your benefit. It's to help me understand what it is we are dealing with here. The witness is called here to come and assist us in our fact-gathering process. A company is mentioned because that's what we know, what the evidence leaders have found a company through whatever investigative processes. The witness knows something else that relates to the very same question, the relationship with Medicare. He knows something else, and he chooses to hold it back. That, to me, is not a witness who's coming to assist the commission. It is catch me if you can, kind of. When in fact, the interest of the commission is to find out what are the facts that this witness knows or that he has in his possession about the relationship with Medicare.
Yes. The witness is not going to take a technical attitude to say, I'm not going to testify to this. What we are discussing is why issues were not in the statement. Now, you may take that position, and that's your view, that that the witness was obliged to deal with matters not stipulated in the notice or the summons. My submission to you is that that's an incorrect view. But be that as it may, it's unfair for you to make the judgment now that he chose to hold back documents when his attention wasn't directed to that. These are transactions that go back several years. This is a witness who deals in companies that have many transactions. So the premise to say he had a duty, even though there's no mention of Tasmika there, to deal with Tasmika, and the fact that he doesn't, that you can put to me that he chose to hold this back is simply incorrect. But all of this goes to no more than the criticism to say it should have been in the statement. We say that's an unfair criticism. Our learned friend can ask the questions. We are not taking a technical attitude that because it wasn't there, you're not entitled to ask the questions. But I do that to neutralize the criticism that this had to be dealt with in the statement. And that criticism is simply an excuse for the Commission having produced this at a late stage. Those are my submissions.
Mr. Bana, my colleague Commissioner Baloyi came in when I also wanted to come in and also to raise a similar point. Mr. Karim himself seems to treat his companies basically either as the same entity, as it were. I know you're going to raise the legal point that they simply cannot be. But look at who was supposed to loan the money. It was Ziki. But I think the money did not come from. Yes, some of it came from Tamiz. And also I think the payment back, was it not to Tamiz as well? Even the payment was not to Ziggy, but to Tamiz. So he himself is treating his companies in sort of a jumble, as it were. So it seems highly technical, as Commissioner Baloyi suggests, for Mr. Karim to now adopt through you this technical legal position that no, we are dealing with separate legal entities. Tamiz is separate from Ziggy, Ziggy is separate from Tamiz, and Tamiz, or rather, and both of them are separate from Tasmika. That, to me, in the circumstances of what has been happening here, is, I feel, subject to what you say, is highly, highly technical.
Chair, we're not suggesting, and I take your point that he's not always kept the distinctions clear. All we're suggesting is that the criticism that he deliberately withheld information from his statement is not one that can be made. And if that is going to be advanced, and particularly listening to the debate with the commissioners, it's all the more reason why we need time to deal with this carefully and properly. Because you are going to draw inferences. We can see that happening already from aspects which we say you should not. But the point I'm making is this. We don't suggest that he's not entitled to be questioned. Your point is correct that he doesn't always keep a strict distinction. But the submission goes to the criticism that somehow all of these entities that are not mentioned in the statement, I say all, but what applies in respect of Tasmika would apply to his other entities, somehow created an obligation on him to deal with whatever was done internally or otherwise, we don't know, between those companies and himself or Ziggy.
Something else altogether, I don't know if Commissioner Kumalo wanted to come in on the same issue, something different altogether. What's your position with regard to the separation suggested by Mr. Shaskalsin? That is issues relating to, is it the infographic? And the schedule. If those are pushed over to Friday, and that everything else be dealt with today still.
Firstly, we're not available on Friday. I'm in the High Court on a matter, and I haven't canvassed my legal team's availability, but Mr. Karim has me here representing him for this leg, so I'm not available on Friday. But we're happy to agree a date as soon as possible that suits diaries. We say there's no prejudice in holding over all of this to when Mr. Karim comes back. It's clear his evidence can't be completed today. It's clear that with a stand-on, we in any case going to eat up into a substantial portion of today. My learned friend suggests a 45-minute or a 1-hour stand-on. It's not in his mouth to suggest that. I don't know how long I'm going to need, but I'm going to do this carefully, and I'm going to take proper time to do so.
If we are not inclined to adjourn so that you should prepare a postponement application, if our inclination is to give you time to consult, what time would you suggest? Mr. Shaskalsin has suggested 45 minutes to an hour. What would you suggest?
Chair, I think at least 2 hours, and I'll come back to you if I need more time. But I do want to say, it seems then that you've prejudged an application that
Mr. Banner, I take strong exception to that.
No.
You know, and you are an experienced counsel, you know that people presiding, let me use the court, the example of courts, you know that judges will engage you during argument, engage you to an extent that you will think they are against you. But in the end, you are surprised that the judgment is in your favor. Engaging counsel has nothing to do with matters being prejudged, and you know that. I take very strong exception to that article.
I don't think...
In fact, I find it unprofessional for you to say that I have prejudged issues purely because I'm engaging you. I take strong exception to that.
I don't think that you should take exception. And
I do.
Can I respond, Chair? What you put to me was that you weren't going to allow an opportunity for the postponement application.
I did not. I did not say I am not. I never said so. We can play back the tape. We can play back the recording.
Then I was mistaken.
So that is, I can actually, to be rough, I can say you are lying.
No, then I was mistaken. I understood you to say that you were not prepared to allow a stand-on for the postponement application to be brought, but you were ready to consider the stand-on to deal with the documents. If I was mistaken in that, then I'm mistaken, but that is clearly how I understood it.
You definitely are. I did not. It was an if situation, which arises all the time during argument.
Then I accept that.
Thank you. And you apologize for what you said, because you basically suggested impropriety on my part that I've prejudged issues whilst the matter is being debated. Are you tendering an apology for that?
Yes, if I misunderstood it, then I tender an apology. But as you say, the record will indicate And my recollection is that you said if you are not prepared.
So you are
for
tendering a
notice-
qualified apology, a conditional apology.
Chair, if I'm
You are
mistaken, if
tendering
I'm
a
mistaken,
conditional-
I apologize, but that's not what I heard.
You are saying if the recording can what, so you are tendering a
It's
conditional
what you put to
apology.
me as well, that the recording will reflect what happens. What's good for you is good for me.
So I'm not accepting